Buddy. And I also want to thank both John and Marco for organizing the colloquium. I think it's a great opportunity to come together and discuss the things on different levels. I prepared a presentation looking on, first of all, different tax systems in the Central Asia to see how does the form and substance stand in that part of the world. And then I have a couple of points I would like to discuss with you, basically have your opinions and observations, because I think I found some provisions in the civil law and I would like to see the interaction of civil law provisions versus tax law. Could we apply that as well or not? And then maybe, if the time allows, I would broaden the discussion or see what is the tendencies happening around the world today, because basically one of the things that probably the previous speaker might have been talking about, and I saw it in his paper, is the recent codification of the substance or business purpose doctrine in the United States. But there are similar things happening in China and India, and I would like to maybe see whether this becomes more relevant for the developing countries going forward. So my brief introduction, my name is Tomáš Balko. I'm actually originally Czech and Slovak. I'm half Czech, half Slovak, from Central Europe. As John mentioned, I was previously working at IBFD in Amsterdam, but then I moved and I was working for 3 years as a tax consultant for PricewaterhouseCoopers in Almaty in Kazakhstan, helping to structure investments into Central Asia, different countries there, and also Mongolia. And I made a difficult decision last year whether to stay and move on with PricewaterhouseCoopers to other jurisdictions or whether to stay in Kazakhstan. Actually, I decided to stay in Kazakhstan and I joined the university on a full-time basis. I was previously just an adjunct. And I'm now trying to work on two major tasks. One of them is to set up a tax research center for the Central Asia and study in more depth the different tax systems in that region. And the other major task is to establish a tax curriculum for a tax program, minor in bachelor and major in a master's program. So if any of these two challenges sound interesting to you and you would like to give me a hand, either with a short-term visit or a longer-term visit, I would be very happy to discuss during the break later. So what I prepared is a snapshot, indeed, of the tax systems and their anti-avoidance provisions that I could identify in the region and immediately in the neighboring countries. So this will take us just a few minutes. And when you will look on those slides, and maybe it's not very well visible, I will just briefly summarize it. In terms of the general anti-avoidance rule, that is overall absent in the Central Asia. I put a maybe question mark with Kazakhstan because I found something in the civil code, and I will show it to you in a minute. From the other anti-avoidance provisions with the international element, the transfer pricing rules, they're actually present in most of the countries, except with the exception of Kyrgyzstan. Okay, then I think capitalization rules, it's like 50-50. Some countries have that, some countries don't. Some have just a cap on what is the maximum interest rate which may be allowed for deduction. CFC rules, 3 of these countries actually have it. Kazakhstan, Azerbaijan, and Tajikistan do have CFC rules. Very simplistic, but they have it as a part of their tax system. Which already brings up a question. There is absence of the general substance of a form, a doctrine, or a concept in tax law, yet there is specific anti-avoidance provisions which use the element of the substance there is the, I would say, the policy consideration or background is the substance in those provisions. When I looked in the neighboring countries or nearby in the region, I looked here on Belarus, Russia, also because they actually just recently concluded a customs union. So there is one interesting phenomenon happening. These countries are coming closer together and trying to create a common market, like we see happened in Europe over time. They are just starting with this process. So the customs union became effective this July, and 2012 they should have the common market. And I expect more countries will be joining in the future. So also looked at Moldova, Ukraine, and I looked on China because it's an immediate neighbor of Kazakhstan. But very similar story with the general anti-avoidance rules, generally absent. I found something in Belarus. It's more like a practical approach of tax authorities when they find out that the foreign entity, or actually it's only in relation to the foreign entities. If they realize it's a foreign entity which may be pass-through entity, and it's not really filing tax returns, they will challenge the transaction, and that they would tend to win in the courts. In Russia, I learned that recently there was a ruling by one of the administrative courts, or actually Supreme Court probably as well, which kind of introduces business purpose doctrine. I have a separate slide on that, and we are lucky to have Evgenia, who is now working at IBFD. Maybe she can comment, because it's really indeed from her jurisdiction, so I may then invite her to make a comment. Very interesting development from China. Basically, as of 2008, or actually there is a little bit of retrospectivity suggested by some commentators. They have general anti-avoidance rule, and also if the time allows, I will just show you briefly how is it basically designed. With transfer pricing rules, it's Belarus and Moldova don't have them. The remaining countries do have transfer pricing rules. FinCap also 50-50, and CFC rules. These countries, except for China, don't have the CFC rules. So there's like just a quick look on what is in that region. So you can actually see almost absence of the general anti-avoidance rule, yet presence of the specific anti-avoidance provisions, which may include an element of substance in them. Now, I would like to briefly think, and maybe if you will have some comments later, why I do think that the general anti-avoidance rule might be missing in the region. It could be possible because of the legal tradition, very formalistic legal tradition, and also which is not even substituted by the courts. There is lack of judicial doctrines, also because the judicial system are relatively young. So the rule of law basically dates back as of the fall of Soviet Union. And so that could be one of the reasons, with the exception of Russia, as I mentioned, because their doctrine is coming from the judicial decision already. And I found something in which we could, such as the abuse of law or sham transaction or substance over form doctrine in the Kazakhstani civil code. I wonder whether there is something similar in Russia. And I didn't have the chance to go through the civil codes of the other countries yet to be able to explore that route. I think other reason why it is absent, indeed, in these countries, there is a very strong emphasis on the form. So form is basically driving the whatever conclusions or consequences. If you don't have the proper form, but it means even your personal documents, you have a serious problem in those countries. So the formal aspects, whether it's accounting documentation, invoices, it's really it's very important. Basically, it's very fundamental. And that's why I wonder, maybe that is the reason why there is lesser emphasis on what is actually the economic substance or substance of the transactions. As long as the form is met, then it's acceptable. From the tax authority point of view, I can also probably understand the fact that they are not very advanced or very developed. So also for a regular tax official, it may be difficult to challenge the economic substance of the transaction, but he may be well able to see whether all the requirements are met formally. That is what has to do with capabilities of the tax administration. And one other possible reason why I think it may be absent is possible fear of uncertainty by the taxpayers, and also maybe the influential groups in those jurisdictions. And maybe also there may be legitimate fears that what is very prevailing in that part of the world is still ongoing corruption and abuse of power by the authorities. Many times the tax authorities do exert taxpayers. They find a minor mistake and they can make it a major issue that with they which extort bribe from the taxpayer, that they will kind of close their eyes and a taxpayer can move on. And if it doesn't happen, if the bribe doesn't come, then they can make it very difficult for the taxpayer. So there is a possibility, maybe the fear that they would give even more powerful tools in the hands of this abusive administration prevents the codification of these rules. As a part of my kind of preparation research, I contacted Victor Turini, who's working in IMF, and he is one of the consultants of IMF who was going around in the early 90s when these countries were gaining independence, and he was helping to draft the tax codes. So I was asking him, why we don't have the general anti-avoidance rule in those countries? And he actually replied, well, he put it in two countries' codes, in Kazakhstani code and in Tajikistani code. And he said, I put it back there in 95, 97. And so indeed, something was put in place, but now in today's codes it's absent. So he also doesn't know what is the reason. Maybe he feels that, oops, what happened?
I think that somebody unplugged the computer.
Which one is it?
Something else. Yeah.
And
I realized
that's
how
okay.
the cable was missing. So.
And so he said basically maybe people felt uncomfortable about using this concept. So that is very interesting consideration. I will just take my computer so I can follow the structure of my slides. If it comes up, I can then switch. I can still keep talking, but you will not see the slides.
Here.
So basically, next I wanted to talk about the civil law.
Welcome back.
Excellent. the civil law provisions that I found, and consider whether they could be used for the tax purposes. So the Article 8 of Kazakhstani Civil Code contains a provision, which is kind of basic principle, which suggests that acts of citizens and legal entities which aim to cause harm to any person or at the abuse of rights of any other form, and also at an exercise of a right in contradiction with its intention, in the case of failure to comply with the requirements specified in that section, one of them includes actually good faith, the court may deny a person the protection of his right. So there's more like a weakening of the legal position. So if somebody would come and try to claim maybe that whatever legal consequences, it suggests that the court may deny that benefit. So it's not that it doesn't necessarily give a tool to the tax administration to attack a transaction, yet if they would challenge a transaction, and if it was appearing that a transaction was carried out or the right was used contrary to the intention of the law, then the court might be less lenient to support the taxpayer position. Even more powerful probably provision is in Article 160, which talks about fictitious or fake transaction, or the sham concept, and that basically suggests that basically defines that a fictitious transaction is one which is entered into only for the sake of appearances, without intentions to cause any legal consequences, and shall be invalid. The English is not very good because I actually copied it from the English unofficial translation, so that's why there needs to be some polishing done. Furthermore, it continues, if one transaction is entered into only for the purpose of hiding another transaction, then the rules shall be applied which are applicable to the transaction which the parties actually had in mind. And here I see more actually the substance over form element in this provision. When I would come back now, my question would be indeed, is it sufficient that we have this rule in the civil code? Can we apply it and then for the tax purposes or not? That would be one of my questions, and I would be interested in your reactions. I would personally suggest probably yes, because the civil law still drives it's a framework for the legal transactions taking place between the parties. If the civil law allows that you can actually disregard a transaction or weakens the right of one of the parties to claim the benefit of a transaction in the court, I think that the tax law should be kind of, at least in Central Asia or civil law countries, should then follow the implications. The tax law should follow the implications of a civil code or civil law. So that's why I think actually they could be used also for tax purposes, although the tax authorities are not using them. And another story I have, 2 years ago in Kazakhstan, we were rewriting the tax code, and I was involved in that process, working very closely with the tax authorities. And I was actually suggesting, let's have the general anti-avoidance rule right in the tax code. And the tax authorities, of course, liked that idea. We came all the way to the Prime Minister, and basically he would hear the arguments, and then he would decide no, he doesn't want the anti-avoidance provision in the tax code. And but on the other hand, so I would say there is something that the tax authorities could use. The question is, they are not using it. Why? Probably it's still too sophisticated or too complicated for them to be able to apply it in practice.
Thomas, can I speak to what you're talking about, or do you?
I'm sorry?
Can I just speak to what you're talking about?
Sure.
In Canada, which is also a very form-driven tax jurisdiction, we have similar concepts in the civil law in Quebec. And in the Commonwealth province, we also have a concept of sham transactions, which are transactions that are given a certain appearance, but they're not really the true legal relations the parties have entered into. So we have this, but that long predated our general anti-avoidance rule, and I don't think that's actually enough to get at what anti-avoidance doctrines try to get at, because typically, sophisticated taxpayers will actually affect like legal relations. They truly will affect legal relations that will comply technically with the law. So they will meet formal requirements. It's not that they're calling something else, and it's really, it's not they're calling it A, it's really B. It's that they've entered into B. They wanted to. It meets the letter of the law, but from some perspective, it's abusive.
Mm-hmm.
It's using the law to obtain a benefit, to escape taxation in a way that wasn't intended. And so I don't think just something that says, oh, we can call this transaction something else is really going to get you what an anti-avoidance rule, judicial or statutory, would get you.
So very practical example or transaction. Some of our clients, and actually also other business parties in Kazakhstan, they will take advantage of an exemption of a capital gain if you sold the shares on the stock exchange for the open market transaction. And so what is being done in practice to avoid a capital gain tax, because if you just do it in a private party transaction, it will be subject to tax at let's say 15 to 20%, depending whether the buyer is a resident or non-resident. And however, so they would basically agree on, okay, let's sell the shares through the stock exchange. They will get listed a company shortly before the transaction. They would then agree on, they would work it out with the brokers, sit down on the other side, and just basically make an offer, corresponding bid. If somebody else enters the transaction, the bidder can still withdraw the offer. So, and they basically play around until basically the two match and the transaction happens. And then basically it has the consequence, which is tax-free. I was thinking maybe the second one might be still, I don't know, might be relevant, because so it was still sale and purchase of shares, yet they play with the form. Instead of making just a very simple direct sale of share, they went for the stock exchange.
The stock
and actually,
market is not taxed.
I'm sorry?
The stock market is not taxed.
As I just explained, there is exemption on when you sell the shares over the stock market. So it was this transaction of going for the stock market. It was indeed hiding just the direct sale. It was you're pretending it's a public market transaction, yet in reality it was a private party transaction. Mm-hmm. So it's very questionable. And it's difficult to see whether how far they would have to stretch it, and how well they would have to argue in the courts to use these rules. And I agree with you, it may not be sufficient, but that's what I could find. Now, briefly, since I have still a few minutes, I hope I will. 5 minutes, great. So I'll just fly quickly through the rest of my presentation, at least to point out some things on Russia here. So until recently, it was also prevailingly form-driven environment, but I understand the things started to change with Yukos case, and then subsequently there was another ruling which came up with a concept or doctrine of unjustified tax benefit, and basically the court here suggested that the unjustified benefit would be in situation when there is absence of ability to produce and deliver goods or services under a contract of the party, and that there is an absence of qualified personnel or equipment necessary to fulfill contractual obligations. Then there is supplementary indicators which would indicate there is indeed this unjustified tax benefit, that it's one-off or one-time unusual transaction. There was wide use of intermediaries to carry out those transactions. There is history of tax offenses by the taxpayer, or there is history of the contractors who committed tax offenses in the past, and also when there is transactions carried out outside of the taxpayer's seat. And basically the doctrine says that the courts, when they would basically determine or adjudicate whether there is a tax benefit or not, they should follow the substance here. I would maybe ask for comments of Evgenia. Maybe I got something wrong. If you would like to comment on that or clarify anything on this, I think very interesting concept in Central Asia, because it's already pure tax focused and it's judicially made. Do you have any comments you would like to make?
Well, all this is correct. I confirm. Just that I can say that this has been developed yeah, in the last 5 years, I think, by the Supreme Arbitration Court. And since then, the tax authorities are very, very active in applying this doctrine. Further explanations or interpretations are being issued now, to make the doctrine more concrete, to cover more cases. From one side, yeah, it's quite a good idea because you get this doctrine, which you can a little bit anticipate what the tax authorities can do if you enter in this or that transaction, but still the tax authorities try to cover more and more cases. They basically use this doctrine in any case that they can't find anything else. So it creates a lot of uncertainty for the business.
Thanks.
So, yeah.
So very short, maybe I would like to outline the topics for discussion that I would like, maybe if the time remains after John's contribution, I would like to discuss with you. So indeed, I would be interested in your opinions if the tax law should indeed follow the civil code implications. So if I can use some of these anti-avoidance provisions in the civil code, whether the implications would spread into tax law and the tax benefits could be denied. Then maybe also whether there is any implications of the global tendencies. And what Stefan, I saw it also in his paper, but he didn't talk about the codification of the substance over form doctrine. I would be interested why now and what is the practical implications in the United States. China, I have a couple of slides on China which outline the anti-avoidance rules there, and also India is has been for the last year debating introducing the general anti-avoidance rule, and I also have a slide on that. But I don't know whether whether I should stop now or you want me to go through some of that.
Probably worth, if you don't mind stopping now and then
Okay.
going through it.
Okay, good.
Thank you very much, Thomas. Thomas is the most globalised of our members here, coming from both